things can get really confusing is you'll see things called mineral deeds that aren't mineral deeds. Just you'll see things called royalty agreements that aren't royalty agreements. You'll see royalty agreements and you read them, they're really mineral deeds. And you'll see mineral deeds and they're actually royalty assignments. There are a million different things. The other thing that we haven't talked about is a lot of the documents you're dealing with here, some of them are from like the 1930s to the 1940s. And you just have to really put that in the context of what was going on in Routt County and Moffat County and what was going on back then. So I mean, there are a lot of really squirrely documents. I mean, some lawyer decides, hey, I'm going to do it this way. He thought he knew what he was doing. It's like you're reading it just like us. Because ultimately, if you can't resolve these things, you have to either file declaratory judgment or a quiet title action with the court, which is, it's expensive and it's time consuming, but, sometimes when you're curing defects, the only way you can cure the defect is, I don't know, it's probably not worth the risk, let's get the judge to tell us, and then it's decided. So, but the title issues are really, they're interesting, from a lawyer's point of view, as I tell my wife. They're very interesting in a very geeky sort of way, because you'll read it one way and it'll be a royalty, you read it different, and then it'll go, look, life's too short, I can't even, I could care less. So, all right, what other questions do you have? Yeah, go ahead, Michelle.
Are all of these documents to secure required to be recorded, like the surface use agreement? Is it definite that they have to record that so we can?
No, that's a great question. Oil and gas leases will be recorded. Surface use agreements typically will not be recorded. Seismic agreements won't be recorded. Rights-of-ways and easements sometimes recorded. Even amongst easements, I mean, there are implied easements. There's, God, you got the extreme. There are adverse possession issues. So, rights-of-ways and easements, they can be recorded. Sometimes they're not. Your well permits, they're recorded. I don't know if record's the right word, but they can be found. Appropriate water, you got to go to the water court. Just go to the county in which the property is located. If you're in Craig, if you're Moffat, go to Craig, pretty self-explanatory. COGCC well permit, that's not going to be recorded, but it's a matter of public record. And then pooling orders, same thing. That's going to be a matter of public record. It could be recorded, typically not. And then, see, this is where the stuff is, other than something we discussed at the break, there's a whole different area that you deal with when you're leasing from the BLM, which is huge, when you're leasing from Forest Service. I mean, there's so many mixed-use land issues. But anyway, to come full circle, I mean, all I'm trying to do is cover a lot of topics here. So, you've been incredibly patient. I appreciate the question and the interest, because, I don't even pretend this is exciting. But, hopefully I at least gave you enough information that you can issue spot and, have a good feeling. And, like I said, if nothing else, just this one list, this will keep you out of a lot of, because if there's a problem and, it's like, hey, I asked for these documents and I didn't get them, you're bulletproof at that point. But anyway, the reason to get these documents is to get the deal closed, because you do not want to find out. It happens. Surface use agreement is a perfect example. It's like someone finds out about a surface use agreement a week before closing. It's like, whoa, wait a second. I didn't want to see all this. Didn't know? So, they can be huge problems at the 11th hour. So, do you have a question? Or?
Well, my only question, or just thinking, if it's not recorded or not a matter of public record, has it been enforceable?
Oh, it depends on.
I mean, if somebody wants to challenge that in court and say, it was stuck in a drawer somewhere, typically have the courts been able? How do they look at that?
Give me an example of
a surface agreement. That,
totally enforceable. Yeah.
I mean, if the person died, and it's
Right.
the kids are going through.
Yeah.
And they don't know that what the agreement is, and they sell the property, and then all of a sudden somebody comes with a bulldozer and said, "Well, we have a surface agreement."
Yeah, every single surface agreement has the traditional successor language that it will, I mean, first of all, it runs with the land. The other thing is that even if the surface owner doesn't have a copy, I guarantee the landman that is responsible for the project, they have them and they have them all organized. So, I mean, that's always a source too. It's like if you know something's going on, you know, NCAC's out there or whoever it is, you pretty much can call the landman, they'll tell you. So, there are a lot of resources.
And how do you find these landmen?
You'd probably have to call me. You'd have to know someone in the industry that,
Okay.
That knows all that stuff. I mean, there's no yellow pages for landmen. If you're out in Craig, Jeff Comstock's a great source. He'll tell you anything. He knows everything before a lot of people. I mean, so, you'll find it. All right, well, you've been a wonderful crowd. I appreciate all your